April 21st, 2025. The Supreme Court just made a decision that the mainstream media is barely covering. And I'm going to tell you right now, this changes everything about firearm permits in America. Here's what happened. The Supreme Court refused to hear Minnesota's appeal. Sounds boring, right? Just another case they declined? Because what this means is that age-based firearm permit restrictions laws that exist in 30 states and Washington, D.C. just got put on life support. 18-year-olds can now carry firearms in Minnesota. Not in 3 years. Not after more lawsuits. Right now. As of April 21st, 2025, the Minnesota Bureau of Criminal Apprehension sent notices to every sheriff in the state. Start accepting permit applications from 18, 19, and 20-year-olds. The age restriction is dead. But here's what nobody is telling you. This isn't just about Minnesota. This is about a domino effect that's about to sweep across America. And by the end of this video, you're going to understand why the entire permit system as we know it is crumbling. Stay with me. This is huge. Before we go any further, I need you to understand something. YouTube doesn't want you to see this video. The algorithm buries Second Amendment content. So if you want to stay informed about what's actually happening with your gun rights, not the sanitized version, the media gives you hit that subscribe button right now and turn on notifications, because what I'm about to tell you is something the mainstream media is intentionally downplaying. Let me set the scene. June 2021, Minnesota. 3 young adults, 18, 19, and 20 years old, can vote, can join the military, can sign contracts, can get married. But they can't get a permit to carry a handgun for self-defense. Why? Because Minnesota law says you have to be 21 dots. So these 3 young adults, along with the Minnesota Gun Owners Caucus, the Second Amendment Foundation, and the Firearms Policy Coalition, filed a lawsuit. They said, this is unconstitutional. We're adults. We have Second Amendment rights. You can't treat us like children. Minnesota fought back hard. Attorney General Keith Ellison, remember that name, defended the law. He brought in expert witnesses. He submitted historical reports trying to prove that restricting guns for people under 21 has hundreds of years of support. March 2023, Federal District. Judge Catherine Menendez ruled for the plaintiffs. She said, 18 to 20-year-olds are among the people protected by the Second Amendment. Minnesota's ban is unconstitutional. But Judge Menendez put a stay on her ruling. She said, the ban stays in place until all appeals are done. July 2024, the 8th Circuit Court of Appeals unanimously upheld the decision. All 3 judges agreed, Minnesota's age restriction cannot be enforced. It violates the Constitution. The court wrote, and I'm quoting directly here, Minnesota has not met its burden to proffer sufficient evidence to rebut the presumption that 18 to 20-year-olds seeking to carry handguns in public for self-defense are protected by the right to keep and bear arms. Boom. Clear. Direct. Unconstitutional. But Minnesota still wouldn't give up. January 17, 2025. Keith Ellison files an appeal to the United States Supreme Court. He asks for one more chance. He tells the Supreme Court, this law protects public safety. Please overturn the lower courts. Please save this age restriction. And here's where it gets interesting. Both sides, Minnesota and the gun rights groups, wanted the Supreme Court to hear the case. That's rare. Usually, one side is trying to avoid the Supreme Court, but in this case, gun rights advocates were confident. They wanted the Supreme Court to rule on this. Because they knew, if the Supreme Court takes this case and rules in favor of gun owners, it's game over for age restrictions nationwide. So everyone waited. Months went by. Briefs were filed. March 10th, gun rights groups filed their response. March 24th, Minnesota filed their reply. And then, April 17th, 2025, the Supreme Court held a conference to discuss whether to take the case. April 21st, 2025, Monday morning. The Supreme Court releases its orders. Worth v. Jacobson. Sut denied. The Supreme Court is not taking the case. Now, if you're not a legal nerd, you might think, so what? They just didn't want to hear it. But here's what that actually means. The lower court ruling stands. It becomes final, binding, enforceable. The Minnesota Bureau of Criminal Apprehension immediately sent notices. 18 to 20-year-olds can now apply for carry permits. Effective immediately. Sheriff's offices across Minnesota started processing applications that same day. But here's the part that should terrify gun control advocates and excite gun rights supporters. No justice dissented. Not one. Not even the liberal justices. Nobody wrote separately to say, we should have taken this case. That tells you something. The Supreme Court looked at this case and basically said, the 8th Circuit got it right. Move on. And that is the earthquake that just hit the gun rights world, all right? Let's talk about why this matters beyond just Minnesota. According to the data, 30 states plus Washington, D.C. have some form of age restriction on firearm permits or purchases. Some ban handgun purchases under 21. Some ban carry permits under 21. Some ban possession entirely. And here's what just happened. The 8th Circuit Court of Appeals, which covers Minnesota, Iowa, North Dakota, South Dakota, Nebraska, Missouri, and Arkansas has just declared that age-based carry permit restrictions are unconstitutional. That ruling is now final. The Supreme Court let it stand. So, what does that mean for the other states in the 8th Circuit? Iowa, Missouri, Arkansas, any state in that circuit with similar laws is now on shaky legal ground, but it gets bigger. The 3rd Circuit struck down Pennsylvania's restriction on 1820-year-olds carrying guns during states of emergency. The 5th Circuit invalidated a federal law that prohibited gun dealers from selling handguns to 18 to 20-year-olds. Hawaii, a federal judge declined to block their ban, but that case is still ongoing. The point is, federal courts across America are reaching the same conclusion. Age-based restrictions on Second Amendment rights don't pass constitutional muster, and the Supreme Court just signaled by refusing to hear Minnesota's appeal that they're okay with that. They're letting these decisions stand. Andrew Willinger from the Duke Center for Firearms Law said the Supreme Court might be waiting for the right case to address this issue head-on. Maybe they want a case about purchasing age limits, not just carrying. Maybe they want more lower court input, but here's the reality. Every time the Supreme Court declines to hear one of these cases, it strengthens the lower court rulings. It sends a message to states: if you keep fighting this, you're going to lose. Now, I need to explain why all of this is happening. And it all goes back to one Supreme Court case, New York State. Rifle and Pistol Association v. Brune, June 23, 2022. The Supreme Court issued a landmark ruling that fundamentally changed how gun laws are evaluated in America. Before Brune, here's how courts analyzed gun restrictions. Does this law serve public safety? If yes, it's probably constitutional. That gave states and the federal government massive leeway. They could ban almost anything by saying, this makes people safer. But in Brune, Justice Clarence Thomas wrote for a 6-3 majority and said, no more. From now on, if you want to restrict firearms, you have to prove there's a historical tradition of that restriction dating back to America's founding era. Not modern safety studies. Not statistics. History. The government has to show that the Founding Fathers and the generations immediately after them would have allowed this type of restriction. And guess what? When it comes to age-based gun restrictions, there's virtually nitrogen monoxide historical precedent for banning 18 to 20-year-olds from carrying firearms. In the 1700s and 1800s, 18-year-olds were considered full adults. They could own property. They could vote in some places. They could serve in militias. And they could own and carry firearms. There were nitrogen monoxide laws saying, you have to be 21 to carry a gun. That's a modern invention. The 8th Circuit in Minnesota case looked at the history and said, Minnesota, you can't point to any tradition of age-based carry restrictions. This law is unconstitutional under Brune. And when Minnesota appealed to the Supreme Court and said, please overturn Brune's historical test, the Supreme Court said, no, we're not taking your case. That's a huge signal. The Supreme Court is doubling down on Brune. They're telling lower courts, apply the historical test. If there's no historical tradition, the law falls. So if age restrictions are falling, what's next? Let me tell you what's currently being challenged in courts across America and what could fall under the Brune standard. Challenge number 1, assault weapons. Bans. We already talked about Illinois assault weapons ban being struck down by Judge McGlynn. That case is on appeal. But the logic is the same. AR-15s are the most popular rifles in America. There's no historical tradition of banning commonly owned firearms. Under Brune, these bans should fail. Challenge number 2, magazine capacity limit. States like California, New York, and New Jersey limit magazine capacity to 10 or 15 rounds. Gun rights groups are arguing there's no historical tradition of limiting how many rounds you can have. These laws are being challenged right now. Challenge number 3, sensitive places. Restrictions after Brune struck down New York's carry permit law. New York responded by designating almost everywhere as a sensitive place where guns are banned. Courts are now deciding, can states ban guns in parks, public transit, private businesses unless the owner explicitly allows it? The Supreme Court just agreed to hear a case about this Hawaii's law that bans guns on private property unless the owner gives express authorization. That case is going to be massive. Challenge. #4. Good cause. Requirements. Some states still require applicants to show good cause or proper reason for wanting a carry permit. Brune was supposed to end that. but some states are still enforcing similar standards. Those are being challenged. Challenge number 5. Waiting periods. California has a 10-day waiting period for all gun purchases. Gun rights groups argue, if I already own guns, what's the justification for making me wait 10 days to buy another one? Under Brune, they're asking, is there historical precedent for waiting periods? Answer, no. On screen. Montage of lawsuits, court filings, legal briefs. The point is this, Brune opened the floodgates. Every gun law that was passed in the name of public safety is now being re-evaluated under a historical test, and many of them are failing. The Minnesota age restriction case is just one example. There are dozens of cases working through the courts right now, and gun rights advocates are winning more than they're losing. Now, let's talk about how gun control advocates are responding to this. Because they are furious. Keith Ellison, Minnesota's Attorney General, released a statement after the Supreme Court declined to hear the case. He said, I'm disappointed. We believe Minnesota has the right to pass laws to protect people from gun violence. This matter will be addressed eventually. Translation, we lost this battle. But we're not giving up the war. Gun control groups like Everytown Brady Campaign and Giffords Law Center filed briefs in the Minnesota case arguing that 18 to 20-year-olds are a dangerous class, similar to convicted felons or people with severe mental illness. They said young adults pose a heightened risk and should be treated differently. The courts rejected that argument. But gun control advocates are going to keep making it. Here's their strategy going forward, and I'm telling you this so you can be prepared. Strategy number 1, redefine historical tradition. They're going to argue that Brune doesn't require exact historical matches. They'll say, okay, there wasn't an age restriction in 1791, but there was a tradition of disarming dangerous people. And modern science shows 18 to 20-year-olds are dangerous, so we can restrict them. Strategy number 2, flood the zone with regulations if they can't ban guns outright. They'll make it as difficult as possible to exercise your rights. More fees, more training requirements, more sensitive places. Death by 1,000 cuts. Strategy number 3, push for legislative action. They're going to pressure Congress and state legislatures to pass new laws. President Biden already called for raising the age to buy assault weapons to 21 after the assassination attempt on President Trump. Expect more of that. Strategy number 4, forum shopping. They allow file cases in friendly jurisdictions like the Ninth Circuit covers California, or the Second Circuit covers New York, hoping to get rulings that uphold gun restrictions. Then they'll try to create a circuit split that forces the Supreme Court to step in. Gun control advocates are not going away. But here's the thing, they're fighting an uphill battle now, because Brune changed the rules of the game. Alright, so what do you need to do? How do you take advantage of this momentum? Action number 1, know your state's LAUS if you're 18 to 20 years old, and you live in Minnesota, Iowa, Missouri, Arkansas, North Dakota, South Dakota, or Nebraska. You are in the 8th Circuit. The Worth decision applies to you. If your state has an age restriction on carry permits, it's now constitutionally questionable. Contact a local gun rights attorney and ask about your options. If you live in other states with age restrictions, pay attention. Legal challenges are coming. Pennsylvania's already been struck down in the 3rd Circuit. The 5th Circuit struck down federal dealer restrictions. Your state could be next. Action number 2, support gun rights. ORGNICATO and the Minnesota Gun Owners Caucus, Second Amendment Foundation, Firearms Policy Coalition, and NRA are fighting these battles in court. They need funding. Even $10 a month helps. These lawsuits are expensive, and they're the reason we're winning. Action number 3, stay INF and subscribe to this channel. Turn on notifications. Follow gun rights organizations on social media. The legal landscape is changing fast, and you need to stay updated. Action number 4, contact your elected OFFICIS if you live in a state with restrictive gun laws. Contact your state legislators. Let them know you support Second Amendment rights. Attend town halls. Make your voice heard. Politicians respond to pressure. Action number 5, be a responsible gun OW. This is critical. Every time there's a high-profile incident involving a young person with a gun, gun control advocates use it to push for more restrictions. Be safe. Be responsible. Get training. Store your firearms securely. Represent the Second Amendment well. Here's the bottom line. April 21st, 2025 was a turning point. The Supreme Court had a chance to stop the momentum of gun rights victories, and they chose not to. They let the Minnesota ruling stand. That tells you where this court is heading. They're not interested in saving gun control laws that can't meet the Brune standard. They're letting lower courts strike down unconstitutional restrictions. Age-based permit bans are falling. Assault weapons bans are being challenged. Magazine limits are on shaky ground. Sensitive places laws are under review, the permit system as we've known it for decades, where states could impose almost any restriction they wanted is crumbling. And it's crumbling because of the Constitution. Because of Brunn. Because of cases like Worth v. Jacobson. This is a marathon, not a sprint. Gun control advocates are going to fight back hard. But for the first time in generations, gun rights supporters have the momentum. We have the Supreme Court, we have the Constitution, and we're not backing down. So here's what I need from you. Hit that like button if this video helped you understand what's happening. Drop a comment below. Are you excited about these victories, or are you worried about what comes next? I want to hear from you. And please share this video. The mainstream media isn't covering this the way they should. Your friends and family need to know what's happening.